Go ahead and if you want to share your video, go ahead and do that. Like I said, most people are already muted. I know we have others that are going to log in as we go through workshop, but I don't want to take up much of this beautiful Saturday, especially while we have the good weather. So we really want to get down to the basics. So today I actually have Rob Owings here. We worked with him in the past as an organization, and he is an estate lawyer. Essentially, this is a workshop where we're going to talk about things at a more high level, right? But the main thing is to drive you to understanding why everyone should have one. If you have a family, if you own property, assets, if you really are just particular about how you are handled, in a sense, if you're dealing with health related issues and who you want to make certain decisions, we're going to get into all of that as we move through today's workshop. So I encourage you that as we go through workshop with Mr. Owens, please make sure that you hold your questions to the end. If not, we can go ahead and I'll check the messages throughout the workshop, and if we find little breaks, we'll get those answered for you. But I'm really excited about this. This was something that was very important too, from handout to hand up, because I was tired of seeing GoFundMes because people did not have the proper life insurance to pay for funerals and costs related to illnesses that we didn't account for, right? Things that we didn't think could happen to us. But guess what? We live in COVID times, right? And essentially, if that's not a reminder, we're dealing with a lot of issues, just as people, really, right? There's a lot going on with a lot of injustices and things of that nature. And the last thing that you want is that unexpected thing happens and you don't have a plan for yourself or to protect your family and your assets. So today I'm very excited. We have Mr. Owens on the line. I'll let him do some formal introduction of himself and then we'll get started.
Thanks very much, Shamira. I appreciate that. My name's Rob Owings. As she stated, I'm an estate planning attorney from Maryland. I'm also licensed to practice in DC. So if any of those people from DC come up, we can handle that as well. So what I'll do today is just walk through the real basics for you, the documents that you should have in place as a minimum, why you should have those in place, and then let you know my contact information. You'll be free to reach out to me at any time and we can discuss things further if you so choose. The main reason you want to have estate planning is you want your stuff, if something were to, God forbid, happen to you, and I always tell people this, right? How many people are going to live forever? None, right? So something will happen, and at some point you're going to want to make sure your assets are steered to the place you want them to go, to the people you want to receive them, and in the manner in which you want them to receive them. The manner being, you don't want to hand a 14-year-old, a big giant chunk of money, because I tell people this all the time. If I had been given a large chunk of money at that age, I know I wouldn't be here. I would have done some nonsense and it would be blown. And we see that happen way too much. And you want to avoid that. Just so that you are aware, there is a plan for you in place. Everybody has a plan, but it's not yours. It's done by the state. If you have no documents in place, the state says this is where your assets will go. These are called the laws of intestacy. Intestacy is just one of those legal words that they use, and all it means is you passed without a will. But the laws of intestacy, the state will say, just look at who in your family, relatives, whoever is still alive, and there's a specific flow chart they use to determine this is who gets what. And it may end up, and I would tell you in 99% of cases, the result is something that you would not have intended or wanted. The state doesn't care about what you wanted. They care about give people the money to make them go away. That's what the state wants. They want them to be quiet. Here's money. And then I've seen people leave third cousins, all their assets because they didn't have family members, but the state found one. And it's almost always an unintended result or an undesirable result. So don't let that plan be the one that steers your assets. Like I said, it does exist for you. The state does it, but don't let the state control it. Do what you want to have done. Make sure you're set up the way you specifically want to set up. Because I will tell you this, If I did an estate plan for everyone on this call, I promise you they would all be different. They would all be individualized. They would all be different. The states is not different for anyone. It just says, here's who gets what, and that's it. So that's the importance of it. That's why you want to make sure you have something in place. We'll walk through the 5 basic documents that I think you should have in general. And then we'll facilitate a discussion after that as far as questions, what you might have in mind, those kind of things. The first one that you should absolutely have is the basic one, and that's the will, right? That's what you need to have in place. That is the document that will say when you pass away, who gets what, how did they get it, and in what manner did they get it. In Maryland, there are very few requirements actually to create a will. They basically just have to be of sound mind. You have to understand that you're doing a document that's going to control the passing of your assets, and you have to be over 18 years old. Once you design that plan, then the will has to be executed, has to be signed by you in front of 2 witnesses who are also over 18 years old and of sound mind, and you all have to be in the presence of each other when it's done. There are some remote witnessing options available due to COVID, but I think it's better, honestly, in person to do it and just take the necessary precautions, hand sanitizer, masks, so forth, just because it's easier for everyone. But no, that does exist. So that document will control the passing of your assets to your family in the manner in which you see fit. What it will also allow you to do is, if you have minor children, it will allow you to say, okay, I want to give my assets to my child, but my child's 2 or 3 years old. I don't want them to have access to this money until they're an adult or grown. And you can specify, this is the age at which I want them to be able to receive the money outright. This is how I want them to receive it. Until then, they can still have access to the money. It'll just be managed by a trustee or someone else, guardian, whoever it might be, that's going to control that for your children and then have it passed on to you as well. Let's also talk about, there are things that are not covered by a will. These are items such as retirement accounts and insurance policies where you name a beneficiary directly. If you have something where you've named a beneficiary directly, that's actually going to supersede your will. That will pass directly to whoever you name it. So if you have a life insurance policy and it says, give it to my child, then that's who's going to get it. It won't pass through your will. So keep that in mind. That's retirement plans and insurance are the examples there. Because most retirement plans, they will not let you open one without having a beneficiary listed to receive your money. So just keep that in mind. Again, the will should be designed specific to your needs. Everyone's plan will be different. We'll set that up and make sure that your assets pass the way you want them to pass. So that's your first document, your will. And the important thing to keep in mind there is your will does not exist until you pass away. So as long as you are competent, of sound mind, you can make changes to your will up until the day you pass. There will be situations where you can't. That would be if you have something like Alzheimer's or dementia or something along those lines, where you're still alive, but you're not in a position to understand what you're doing and work on your documents and so forth. So just keep that in mind. If you do a will today and in 10 years from now, your situation looks very different, well, then you can go back, as long as you're, like I said, of sound mind, you can go back and make those changes. So it's not set in stone until you pass, or until you get to a point where you're not competent and you can't make those changes anymore. So that's the first document. That's the will, and that exists when you pass away. The other documents that you want to do are to address an issue where you haven't passed, but you're, again, an Alzheimer's or dementia type example, you're still alive, but you can't manage your finances, make decisions, you're not competent in that way. And believe it or not, that happens far more frequently, because you can only die once, right? But you could become incapacitated, you could become disabled at any time. And those documents there's 4 of those total. The first one is your general power of attorney. General power of attorney covers things like financial transactions, mortgages, those type of things, investments, all that stuff. And what that document does is it just grants someone the right to act on your behalf if you're not able to do so. So what it says is, hey, I'm no longer competent. When I'm not, can you please have this person has the right to make these transactions on my behalf? Keep in mind though, because that can sound scary, right? Giving someone access to your bank accounts to do these things for you, but they are also bound by law to act in your best interest. I will tell you that I've been in cases where judges have seen someone have a power of attorney for someone and do something that's not in their best interest, and they do not like it. They will go come down harshly on anyone that's supposed to be acting on someone's behalf and doesn't do so properly. So you do have that protection. And again, that durable power of attorney is the one that is going to govern your financial transactions and any general business transactions that you might have. So that's your first power of attorney that you would need. The second one is similar. It's called the Maryland Personal Financial Power of Attorney. This is only for people that are Maryland residents, because as I told you, I'm barred in DC as well. So with DC, you don't have those. You don't have this. This is only for Maryland specifically. A lot of other states don't have it either. So, but this is called a Maryland Personal Financial Power of Attorney, and this is more for banks and things like that, to be able to write checks and to be able to conduct business on behalf of someone that's no longer able to do so. The reason we do a separate one for Maryland Personal Financial is that in 2011, Maryland passed something called the Power of Attorney Act. And I don't know why they did this, but so in every other instance, there's laws that say, hey, for wills and powers of attorney, this is what you have to have. But for the Maryland Personal Financial Power of Attorney, they actually put a picture of the form in the law. So if you don't have that particular form in that fashion and done that way, and you go to a bank to try to execute transactions, they can give you a hard time. So that's why we do that. That way, if you walk into a bank and you have that personal financial power of attorney and it exactly matches the one from the law, then the person at the desk at the bank is not going to give you a hard time. But if you come in with a different version of that and something that doesn't look exactly similar, I've seen them give people a hard time. And that's the last thing you want if you're in that situation, is somebody giving you a rough time about that, because you're already trying to help someone that needs help. So there's no reason not to do this one, to just make sure that that's all good to go. Then additionally, what you would have is there's another power of attorney document. So this is the third one, and that's your healthcare power of attorney. And what that does is exactly the same thing. That accomplishes granting someone the right to make healthcare decisions on your behalf. If you're in a situation where you can't, maybe you're injured and you're in a coma, you're sick, but you're still alive, someone has to be able to make those decisions for you. Someone has to be able to speak to the physicians. Someone has to be able to look at medical records and decide what is best for you. So the healthcare power of attorney does that. It just gives someone the right to act on your behalf and to do that for you. Now, that is, again, this is something I think you really need to have in place, just because the likelihood that will happen is much higher than the likelihood of you passing it, because again, you can only pass away once, but you could get sick numerous times or any number of times and need someone to be able to make decisions like that for you. So that's your healthcare power of attorney. Those are your three power of attorney documents. And again, powers of attorney are for while you're alive. They're for somebody to transact business or make healthcare decisions or do banking transactions for you while you're alive. As soon as you pass away, powers of attorney no longer exist and your will kicks into play. So that's why you do both sets of documents, because when your will doesn't exist till you pass, and your powers of attorney only exist while you're alive. So they work with each other. So that's why you do those in conjunction with your will. The will's for when you pass, the powers of attorney for while you're still alive. And then the last document that's an optional one is called the living will. Living will is basically end of life decisions. Those are decisions such as, please don't keep me alive on a machine, or please donate my organs if I pass, or don't, or whatever your preferences are. But these are basically end of life wishes. Do you want to be sustained artificially? Do you want to donate your organs? Do you want to do any of that kind of stuff? And so that is what the living will actually accomplishes. So those are your 5 basic documents. You want those in play just because, again, the 3 powers of attorney and the living will contemplate what happens while you're alive. And then that will kicks in when you pass. So if you have all 5 of those basic documents in place, then you're covered from every direction. So you're covered while you're alive, and then you're covered again once you pass. So At a minimum, that's what everyone should have. The living will is one that you may or may not need. That really is a client-specific choice. But the powers of attorney and the will you definitely want in place. Another thing to think about when you're thinking about these things is, are you going to be in a tax situation? So right now, the exemptions for estate tax are very high. In Maryland, you get to pass $5 million through your estate without paying any estate tax. And at the federal level, it's actually higher than that. It's $11.58 million. So as long as you're under $5 million, if you're in the state of Maryland, you're not going to be subject to estate tax. So that's something important to know, because if you are over that amount, we'll have to do some additional planning and try to get you to the point where we're avoiding some of those taxes. Estate tax is by far the worst one to pay, but it's also one that you can plan around readily if you just take some steps and some precautions. So that's where we stand on that. Those are your 5 basic documents. That is the tax situation you're looking at. And please, if you remember nothing else from this, just definitely get those minimum documents in place. We may sit down, if you reach out to me after this, and say, okay, we have our documents in place, but I have a tax situation, or I have a special needs child, or I have some other issue. And it may very well be that we need to do additional documentation or make changes to what we would otherwise do because of your specific situation. But those 5 are the documents that everyone should have at a minimum. Now, what they say and who they grant powers to and so forth could be, their odds are they'll be completely different. But in some fashion, you should have those 5 documents in place. Let's see, that covers all those. There are also, you can also do trusts. A lot of people hear about revocable trusts, so I'll cover those really quickly. Trusts are not a requirement, but they are something you can do. And it may be that that's a better option for you given your situation. A trust is basically a will substitute. And what it allows you to do, it accomplishes the same thing as a will, given that it's going to say, here's what I have, here's what I own. Let me pass my assets through this, and this is who I wanted to go to, so forth. So it's going to function like a will, but it has a few specific things that a will doesn't have. So with a trust, you can avoid what's called the probate process, which is, remember what I told you before at the beginning, the state rather has a plan for your assets if you don't have any documents. And even if you do have documents, you still have to go through the probate process, which is the method by which your estate's done, accounted for, distributed, et cetera, et cetera. So that's something to keep in mind. It can be a lengthy process. It's normally at least 9 months. The reason we know is 9 months is because there is a deadline from 9 months from the date that you pass that you have to file final tax returns and so forth, if any are required. So given that deadline, they're telling you they expect it to take at least 9 months to get everything settled. So it's not an easy process. If you have the right documents in place, it's certainly much better and much smoother, and you can have the person you want in charge. If you don't have documents in place, it really is an administrative nightmare because it's not an easy process to sit down and go through. So one of the benefits of doing a trust is that you avoid that probate process. Another benefit is you can actually keep your stuff private. So when you pass away, your will has to be filed with the courthouse, and they have to read it, approve it, all that other stuff to make sure that it's okay. So a trust, you don't have to file. It's not public record because you're avoiding that probate process, so it's not required. A will, you certainly have to. You have to file that. It's got to be probated. Everything has to be done. So just keep that in mind. That's a trust. Privacy is another big benefit. Some of the cons of a trust, they're more expensive to set up initially because there are several things you have to add to a trust document. Additionally, you still have to do a will if you have a trust, but your will be very short. It's called a pour-over will. And what that would say is, hey, if there are any assets that I forgot to title in the name of my trust, or I forgot to properly place in my trust, please put those assets in my trust and distribute it per those terms. Ideally, once you do that, you're not going to have any sort of assets still left out there, because what you're going to do is you're going to have them all in your trust. It's going to skip your will, and it's going to go per the terms of the trust. But just recognize that you still have to have a will just in case you forgot to put something properly in there. One of the other cons of a trust is you have to retitle your assets into the name of the trust. Normally, that's not a big deal. There, you can certainly contact banks, financial institutions, brokerage houses, any of those type of places, and they will do that for you. And they will usually do it free of charge. You might have to sign a piece of paperwork or something like that, but it's not going to be anything really specific that you have to do, other than, you know, just making sure you give them the paperwork, they properly title it, you sign off on it, and so forth. The only real cost is for things like houses. You have a house that you want to put in a trust, you have to file a new deed. So keep that in mind. There is that cost that has to be completed. So again, the cons of it, the pros of a trust: it's private. It avoids probate. It can account for assets while you're alive as well as after you pass, because a trust does exist while you're alive, where a will does not. So those are three of the pros. There are a couple others. I won't get too deep into that. Some of the cons are: A, it's more expensive in the beginning, and B, you have to go through the exercise of retitling all your assets. So those are things to keep in mind, because you'll hear that term revocable trust thrown around, and that's what it is. It's a will substitute. It can accomplish the same thing. So you should at least know about that and know that's an option. But what would happen is, when we sit down and gather all your information, it will be pretty easy to look and determine, you know, here are reasons why you don't want to do a trust. Here are reasons why you do, and is it worth it for you to do it? So that's an analysis we would have to do individually. I just wanted you guys to be aware that it exists and that it's something that you will run into and you might consider. And again, that's a case-by-case basis. So that is where we stand with all the documents you would need. And again, the reason why, if you learn nothing else from this, even if you don't use me, please make sure that you get your plan in place so that you're not left out in the breeze and you're not left making the state decide where your assets go and when. So that's really a high level view of things. That's what I wanted to do. I've been talking for, I don't know, almost 30 minutes. So what I'd like to do now, if we can, is just open it up and give you the opportunity to ask me questions, to discuss things and so forth, if that's okay with you, Shamir.
Yeah, that sounds great. Because I'm leading this, I will wait till the end for mine. So, because I
That's
have a
fine with me.
so if you guys want to just go ahead and unmute yourself when you have a question, and we'll just go ahead and go around everyone who's logged in with your questions and concerns. I'm telling you, if you have it right now, is the great time to discuss it, because that question you have, someone else may have. So we're really helping one another out on this.
That's correct. And I promise you, if you guys have that question, somebody else does as well.
Okay, I don't have a question right now, but I'm thinking a friend of mine has a question who's not online, and I'm asking this question best I can in her behalf. So she recently had her sister recently passed. She has a home. She didn't, so she's passed. She has left 3 siblings behind. So I think they are now, they get whatever she left behind. But what does she do? Like her sister had a boyfriend who lived with her for like 25, 30 years. Now, of course, they will probably have to put him out of the house that they lived in together, because it was all in her name and everything was hers, and she probably paid for everything. But she just doesn't know what direction to go in, or even how to start it, what to do with it, where to go with it. I'm just thinking about the home right now. That was a question that she had recently, actually about 2 weeks ago, she asked me, you know, what do I do? How do I even start this?
First,
Rob, did we lose you?
My question was probably too long. Sorry. I think he's just frozen.
Yeah, he probably can hop back on.
Oh, just. Can you guys hear me? Okay, sorry about that. Technical difficulty.
Yes.
But yes, so the answer to your question is she has to put the house in the estate first. Then she would have to do a deed from the estate to the 3 siblings who received the house. And then they can decide ultimately what to do with the house after that once it's in all 3 of their names.
I'm sorry, put the house in estate and then deed the house from the estate to the 3 siblings. Is that what you said?
That's correct.
Thank
Yes.
you.
Yeah, that's generally what she would do. If she has specific questions, she can certainly reach out to me and I'd be happy to help.
Thank you.
Mm-hmm.
Thank you.
You're welcome.
All right, anybody else? Well, I have a question. I'm gonna go ahead and jump in.
Okay.
I have a question.
Oh,
Oh,
okay.
okay.
Go ahead.
This is Anthony J. Footman.
How you doing?
Calling from Maryland and serving. I have my parents passed, mother and father.
Okay.
There's still a house in Richmond, Virginia and stuff, that 3 of the siblings somehow got executive estate privilege. I'm not sure how that works, but I was never part of the process.
Okay.
So do I need to is there a time limit for me to do anything or what? As far as,
I'd have to look.
Received my
Yeah,
portion of the estate.
Well, did they have wills and everything or no?
No, they didn't.
Okay.
And what will they had, there was never an executive estate assigned and stuff, and they were all in there and signed themselves up as executive estate. So it's a big mess.
It sounds like it.
And it's part of Shamir inheritance too.
Yeah. So what you want to look at is the Virginia laws of intestacy. Intestacy is INTESTACY. The Virginia laws are going to say where that property has to go. If they didn't have a document, that's what the fallback is. So we'd have to look at that and see, what do those laws say, who gets what. And if you're, I'm guessing, I don't know Virginia, I would have to look at it, but I'm thinking off the top of my head that where your parents, so Virginia is the location of the house. So yeah, you need to look at that. But the Virginia laws of intestacy should, I'm sorry, what?
It was in Henrico County in Richmond.
Yeah. So, okay. Yeah. You would have to look at the Virginia laws of intestacy and figure out what they say as far as who gets what from the estate. And then even if your other siblings are executors, that doesn't give them the right to say the house goes here or there. The laws of intestacy in Virginia say where that has to go. And if they don't abide by those, then you can take action there. So you want to look at those Virginia intestacy laws and see what they say. I mean, I know in Maryland, for example, it would say it gets distributed equally among the kids. Like I said, I don't do Virginia. I don't know off the top of my head, but I'm guessing it's something along those lines.
All right, thanks a lot.
Certainly.
Hello, can y'all hear me? This is Valencia.
I can hear you, sure.
Okay. So I actually have 2 questions. My first question is in regards to your beneficiary.
Yes.
So is there a way, so basically my son, will be 13 soon. If I have his father as 50% beneficiary and then my son as 50%, does that mean that his dad will get a portion to be able to provide for him until he's 18 and then he gets his 50%? Or how does that work?
If you do your documents that way, yes. What you want to do is name someone to be a guardian / trustee for your son until he reaches the age that you choose. It doesn't have to be 18. It can be higher than that. Obviously, it can't be lower. I've seen people do it 25, 30, 35, whatever you so choose. But what you want to do in your documents is specify that this person manages your son's 50% for his benefit and in his best interest. And then whatever age you so choose, your son can then have full control of the assets. But you would want to make sure you specify that in the documents.
Okay. And then my second question is in regards to like your will and being hospitalized. If you choose to do a DNR, if that is in your will and you get married and you decide to keep that in your will, can your husband or your family choose to not abide by that because you're now married? And I don't know the law as far as if you're married, your husband now has say so when you're at that level.
Yeah, well,
or
you
will
wouldn't
the
do that.
DNR just stay in effect?
Yeah, you wouldn't do a DNR in your will. You would do that in your living will or advanced medical
Okay.
directives. That's the end of life wishes document. It's a separate document.
Okay.
You can set it up to, normally what I do is I set them up so, and again, this doesn't mean yours has to be that way. You can choose to have it differently. I usually set up the living will to say, these are my wishes, but my healthcare power of attorney can overrule that if there's a conflict. If there's no conflict, then you don't have to worry about it. But yeah, no, they can't overrule the documents. They're not, that's why we do these documents, is to make sure your wishes are specifically outlined. I give the healthcare power of attorney a little bit of power there just because you might have a DNR, but then the doctor says, hey, I can actually completely fix this person if you let me do X, Y, Z.
Okay, gotcha. Okay.
Yeah, so I don't really like to do strict DNRs just because of that, because I'm afraid that I will tell you, I had a relative who had Alzheimer's, and my dad said, if I ever get that, I want you to just let me go. And I'm like, no, because I know what'll happen. I'll be the person that does that, and the next day there will be a pill that cures it. Right. So that's why I leave the healthcare power of attorney a little bit of a window to make some decisions there that your living will might not be able to contemplate.
Okay. And with that, it does not have to be like, so I have my mother and then I have my son. I would be able to say, okay, I would like my mother to be in that part is if I have a DNR, and I would maybe allow her to make that decision. Or if my son is 21, he would have to be listed. Or how does that work? Can I say I want it to be my son, or I want it to be my mother or my husband? I really I could just put that at any way that I want it. It doesn't have to be a certain family member or kin to you.
That's correct. You can specifically choose who you want to have it done. You could even put something in there that says, I want my son to have control, but only if he's at this age when something happens. You can specify it that way too. But no, there's no requirement as to who it might be. The only thing I would tell you is when you're thinking about these things, try and make it someone that's not going to have to, like, for example, I had someone that named a power of attorney that lived in California. Well, that's a giant pain because that person now has to fly back and forth every time something happens or every time there's a decision to be made that can't be done electronically or over the phone. So just try to think about that. I would tell you, try and make sure that it's somebody that is going to, A, want to do it, and B, that it's not going to be so inconvenient that they can't get there. So try to keep those couple of things. And other than that, I would say do, whoever you think is best suited to that. Because remember, this is the person you're going to have taking care of you if you're alive and these things take place. So think it through, make sure it's somebody you want, but also try and make it so it's somebody that will, not have to go that far out of their way to do it. Make it convenient for them.
Okay. All right.
Because in turn, that'll be convenient for you.
Okay. Thank you.
Certainly.
I have another question, and I should first apologize for my lateness, but I had a meeting from 10 until 12. And
no, that's no problem.
It took me a little late getting on. But the things that you suggested, and I did get in as for the three items, the three power of attorney items, the will and the living will, the estate tax, the trust, and then the information that you gave me. Are these things that you can do on your own? Like the information you gave me for my friend who the estate, to set up an estate. put the house in the state, you said, for example, can she do that on her own, or does she need to go to a professional to do that? Or can she
That
just pull
part,
the form that she can fill in?
yeah, the administration part you can do on your own. It's not easy and it's a headache, but you can do it. What I would tell you not to do on your own is try to write the documents yourself. Meaning like your will and powers of attorney and that kind of thing, because there are very specific things that need to be included. And if you miss one of those and your will gets invalidated, then that causes way more trouble than it would otherwise be worth. So you can do the administration and the estate stuff without an attorney. That is absolutely possible. Especially if there's only one asset like a house, it's probably not as cumbersome as it would be if you're dealing with a large amount of money and things like that. What I would tell you is that, you can do it. It's not easy, but it can be done. And you can call the Register of Wills in the county where you're doing it, and they'll give you some guidance. They won't give you legal advice, but they will tell you maybe what forms you need and stuff like that. But I would certainly tell you not to draft documents on your own or not try and write your own will and things like that. You can get a will like that recognized, but we always say that if you're doing that, what you're doing is you're making the opening for contest for somebody to contest your will wider and wider and wider. You're giving them much more room to say, okay, it didn't include this, therefore it's invalid, or this didn't happen and that's invalid. And things like that can happen. I saw a will get invalidated because one of the witnesses signed it, but it turns out she was in the other room getting a drink when the person actually signed their will. But she signed it saying, I was in their presence and I saw this. Well, no, you didn't. And that person's will got thrown out because they found out that she didn't, in fact, witness that signature. So I don't think the risk is worth it to try to do your own documents, but you can certainly try to do the house stuff and things like that on your own.
Okay, thank you so much. Thank you again.
Certainly. Yeah, no problem.
Okay, so I have a question.
Sure.
So I know you said that when it comes to retirement plans and insurance policy beneficiary, that they will supersede a will.
Yes.
So my question is, because I feel like my situation is a little bit unique in the sense that, like, I have included or want to include my godchildren and also my boyfriend's son, in that regard. So my question is, does that mean that I should actually have them listed as beneficiaries as opposed to having who I have listed now, and then that person dishes it out, I guess?
Yeah, no,
Right?
you don't want that, because from a technical legal standpoint, if you do it that way, the person that you're having dish it out is giving a gift, because it's technically the beneficiaries weren't there. So what I would do is just list them, and you can use percentages, which is good. So like you could say, I want my boyfriend's son to get 10% or 5% or whatever it is, and you can just specifically list who you want to get what and what percentage. That's the best way to do it. You don't want to put that on another person to dish out, because one, they may not. I mean, just because they may not, and two, they're not legally bound to do it.
Understood. Okay.
So what that means is basically, if they're, let's say, one of your godchildren said, Shamir wanted me to get this, and there's no documentation saying that, not that this person ever would, but they could simply say no, and there's nothing your godchild could do about it because it's not written anywhere.
Okay. I think my other question is that, so I have specific instructions that I want, as my daughter is listed as a beneficiary on one of those accounts. So essentially that will would put someone to manage that money for her, and because she is a minor, and determine and go through what I have listed in regards to what I want her to use that money for.
Correct.
Okay.
Yep. You just so in that situation, you just have to make sure you pick somebody as a guardian that's going to do that for you and is willing to take it on and will abide by your wishes.
Okay, understood. Yeah, because and I'm okay with speaking with everyone here. So I'm actually working with Mr. Rob on a lot of this. I have a minor daughter And one of my biggest things in accomplishing is that in the time of my death, that the money that I leave to her, that she uses to pay off my home, which is essentially her home. And I'm doing that because I've seen, especially in some of the things going on with my family, is that, you know, we might lose a house, or it goes in on whatever docket, right, or foreclosures or whatever, and things of that nature. So my goal is that if indeed I do pass before I pay off my home, is that this money that I'm going to leave, that she'll benefit from, that manager, that trustee, that guardian will say, okay, no, this is the money that your mom said is going to be used to pay off the home, so you'll always have property, like you'll always have your own home. So that is like one of my biggest things that I wanted to get accomplished before the year is out, mainly because I don't want, in the time of my death, it's like, okay, here's this pot of money, and now what? You know, I want to be able to say, nope, at least I know she got a home she can come to. Her father continue to raise her here with her brother. Everybody's safe and secure, and maybe I'll sleep at more peace in heaven. Who knows?
That's right.
So that's kind of just where I am personally on my estate planning journey.
Yeah, and we can certainly accomplish all that for you.
I have a question.
Certainly.
So my biggest thing is my grandson, and
yes,
should something happen to me, I do not want neither one of his parents to have access nor be able to dictate anything that happens with the money. I want to be able to ensure that, you know, there's some form of stipend that goes out every month. If it should be that I leave before he reaches 18. So something that goes out every month to help, you know, cover some of the expenses, not to be the primary, you know, source of covering their expenses, but covering some of his expenses. However, if they need something, if something's like a need, like, I don't know, he needs braces, or they want to put him in a special camp, I do want that opportunity that they can go to whomever. So I'm assuming, one, I would need some type of trust person to manage the money. But then the question becomes, how do I make it so where they can't just say, oh, we want braces for him, and get the money and not get braces? Like, I want to be able to have something that's going to be in place that once the money is given, and I don't know if that's a possibility, but I want to ensure that if they're asking for something extra outside of what he can get every month, that's what it actually went to.
Yeah. So what you would do in that case is name, you know, you can't name anybody else guardian for him because his parents are alive. So that you can't do that. But what you can do is name an independent trustee who is not either one of them to manage that money. And they can say things like, you know, you can set it up where it's reimbursement, where if they, you know, get the money for the braces, then the trustee will pay it back, or the trustee will pay the dentist directly, something like that.
Okay.
But yeah, you can certainly set it up that way. You would just have to name your own independent trustee to manage his assets.
Okay. Yeah. And would you have like, because I definitely am going to need to reach out to you and schedule an appointment, but do you have like resources about who are trustees, you know, like a company or an agency that does that, so that they could take that over? Yeah. So that's like one of my biggest concerns, is just making sure that he's okay, but you know, his parents have to figure out what they're going to do in life. I can certainly do that for you. And I will tell you this, I have seen cases where somebody mismanaged assets for a minor, and judges really don't like that. So whoever's the trustee is going to be bound by those rules. And I promise you, if they deviate from them, there are very few things that judges dislike more than that. Okay. All right. That's good to know.
Yeah.
Okay. One other question, and this is just from on the business side of things. I have an agency serving individuals with disabilities and aging. One of the biggest concerns that always is with the people who have children with disabilities.
Yes.
If the parent passes away and they leave something, that can get in the way of that child getting supports from the government.
Yep.
And so trying to figure out what is out there for them that allows that child to still receive their parents' you know, estate, but doesn't get them kicked off of Medicaid, doesn't get them put out the waiver because they have too much money. So
Right.
is that
And
something also you work with?
yes, that's called a special needs trust.
Okay.
And you'd set those up, and they're specifically designed so that money can be managed and kept for the child and still used for certain things. But it also, at the same time, because it's not their money outright,
Mm-hmm.
it won't disqualify them from government benefits. It's specifically designed for that purpose.
Oh, okay. Okay. Awesome. Great.
Yeah. Yeah.
Thank you so much.
Oh, certainly.
And you do special needs trust as well? Because
Yep.
I actually had someone who reached out and wanted to know specifically.
Yes. Yes. And you can do them as part of your will, or you can do a separate special needs trust and put funds in it while you're alive. You can do it. There's a number of different ways to do it, but we can certainly handle that for you.
Okay. All right. Does anyone else have some last minute questions? We still have a little bit more time. At least now, Rob, can you provide your contact information while we're waiting for anyone else with questions, so that way we can really know how to get in touch with you?
Yeah, certainly the best way to do it is I will just give you all my cell phone number. The best way, that's the best way to reach me. It's 443 977 8640. That is by far the easiest and best way to get in touch with me.
So again, this is from the latecomer, Sharon. You're a lawyer?
Yes, ma'am.
You are a lawyer, okay.
Yes, ma'am.
Thank you.
Mm-hmm.
Repeat your number, please.
Certainly. 443 977 8640.
All right. Yeah, I think
Hey, one more question.
okay, go
Sure.
for it.
Yeah, what other practices do you cover?
Estate planning is my main practice area. That's the one that I really do well. I also can do some business planning, and those are the two main things that I focus on. I do have some knowledge about tax law as well, but that's not one of my main practice areas. So mainly it's the estate planning and administration.
Okay, all right, thanks a lot.
Sure. But if you keep in mind, though, if you have questions about other topics, I have a large network of people that I can refer and send you to the right place if it's something I can't handle.
I do have one more question
Sure.
before we wrap up. So I know, as you said before, the Maryland Personal Financial Power of Attorney, particularly for when people are doing interactions at banks. Now,
Mhm.
does that kick in? Is that pre-death, like so you're incapacitated or you can't go into banks to handle whatever financial transactions, or this actually once you have passed, this allows them to have access to your bank account and things of that nature?
It's for while you're alive. So powers of attorney cease to exist when you pass
Right.
away. Yeah. So they're gone. As soon as you die, they're gone and your will kicks in.
Okay.
The power of attorney is for you're alive, but you know, something has happened that you're not deceased, but you at the same time can't make those decisions or can't perform those tasks on your behalf. Because we know they're not going to stop sending you bills, right? So you got to have somebody to be able to do that for you. And that's where that power of attorney kicks in.
And I came up with another question. This is something I hadn't thought about it. I hadn't initially thought about it, but I know I feel like you're going to say, well, it's very expensive to not have these things. But is it very expensive to get these things? For example, to come to you and to have all of this stuff set up. Does it cost a lot of money to do that? And I'm sure that on the flip side, it would be very expensive not to do that because you lose things. But
Right.
still, is it very expensive if you're just a regular person? Can you
Yeah,
really
well,
afford that? You know,
no,
I'm
it's
not like
not, it's not
super
terribly. Yeah, it's,
rich or
well,
anything.
yeah, I mean, I certainly can't quote fees to you having no idea what your
Of
specific
course.
situation is. Yeah. But no, I like to do these on a flat fee. Once we meet and figure out this is what you want to have done, then I can tell you, okay, this is what it would cost. And you would know that before we started doing anything. And you could say yes or no at that point.
Okay.
But
So
what
regular people with just a little something, like a house and just that, it's still within there, not within there, I don't know how to say this. You people, regular little people can still do this, I guess.
Yes.
I always thought of these things as things that people who, you know, are multimillionaires accomplishing, not just regular little people.
Well, I don't, that's definitely not the case. You certainly want to have documents. What you're doing is you're saving a headache for the people you're leaving stuff to. That's really the way to look at it. You're saving headaches for the people that are going to receive your assets by doing it. And no, it's not terribly expensive to do basic planning. It's more than worth it in the long run because you don't have to go through all those intestacy laws and do all that stuff after the fact. And it's even more worth it if you become disabled and you're still alive. If you don't have those powers of attorney in place, no one's allowed to do things on your behalf. Then they have to go to court, be appointed your guardian. There's a whole host of things that goes along with that, which is really a headache.
Okay, thank you.
Mm-hmm.
Yeah, I know when we were discussing as a team in regards to what workshops we should bring, estate planning was definitely one of those things, like where you say estate planning, like, am I swanky? Like, do I have all this money and things? But an interesting story that a good friend of ours had experienced is that, you know, she was in her 20s and she was essentially diagnosed with Guillain-Barré, and she was not able to communicate or move on her own behalf. Now, mind you, she started with flu-like symptoms, and then within a couple of days, she was admitted. So the question was, who was going to take care of her and understand her needs, and who was going to act on her behalf? Now, and again, this was just a person who was just out with us like the week before, hanging out. We were getting ready for a birthday. And then essentially, you know, day to day, being a nurse, she had to get a flu shot, and she was diagnosed with Guillain-Barré. And like I said, to have the firsthand experience when you're seeing a person having to figure out how do you communicate with someone who doesn't know where your documents are, and I can't tell you, or who do you call, or how do you handle things of that nature. And I think a lot of times we have to remember that, especially as a God-fearing people, is that, you know, tomorrow is not promised and we don't know what it holds for us. So if we can do whatever we can to put certain things in place, you know, that will help the situation along. I mean, it's not going to make it better completely, right? Because you want your health back. But nonetheless, those people that are there to support and love you can do that most effectively when they know what your needs and wants are and know where everything is and stuff, instead of as I've seen it, going through grandma's drawers trying to find paperwork all over the place, you know. So and that was a witness to see. I actually I can remember that vividly when my grandmother passed, like this free for all going through paperwork trying to find stuff. So that is why I felt, and the team felt, that we really had to get this information out to the community and stuff. So we're truly hopeful that everyone here will reach out to Mr. Owens, discuss your personal situations, you know, make sure you have it on it. Don't write it off as it might be too expensive until you hear that it's too expensive. Or, you know, get your quote in and say, okay, maybe I can do this at another time, and save toward it, you know, because at least then you know, okay, I have an idea in mind, but I know I also need to get this done. But I do think it's very important that we as the people just, number one, take advantage of, you know, those policies out there, the means of protecting our voice when we don't have a voice anymore, you know. So nonetheless, Mr. Owens, I want to thank you for your time. Does anybody else have any other questions?
All right, I have one more. I talk a lot. Okay, I have one more. So now I'm a little confused. So hand out, from hand out to hand up is not Mr. Owens. Mr. Owens, this is, it's not the same thing.
No,
No.
this is,
Person that they brought in. Okay.
So From Hand Out to Hand Up is actually a nonprofit organization, and we're essentially funded behind bringing personal and professional development to those individuals who may not have access to certain resources. The key is that we're just pushing life skills, we're pushing adult education, we're pushing, the things that we may not have the most verbiage or experience with. And essentially what we do is we reach out to all these individuals who are professionals and certified to talk about things. Because I feel like a lot of times we get huddled up with our good girlfriends and family.
Right.
And
Everybody
they
got an
Google
opinion.
monsters, right? They Google their way out through anything and they think they know.
Yes.
And that is not the case. So we wanted to get and connect people to actual certified individuals who know what they're talking about. The ones that have spent years studying this, who have the legal, the ESQ behind their signature, because they're the ones who actually know, not the what I heard or what Google says or what happened to my friend 4 years ago. So we connect those individuals with our organization, and they take time out of their professional schedules to assist us with this. So the goal is that, you have someone, as we build our network, that we can reach out to who's willing to assist, but also showing people how awesome these individuals are and how they can help you accomplish your goals as well.
Thank you. Now, thank you.
And no problem. I'm glad
I appreciate both of you. Hand out to hand up, and
hand out to hand up. Yep.
Dr. Owens. I appreciate both of you. And the meeting that I was just that I just left, one of the targets, one of the things that they talked about, they are starting a list of Black-owned businesses. So and they said, it doesn't just have to be members of our organization, but any Black-owned business. They want people to know who the African Americans are, who have businesses that they can tap into. So I would like to be able to give Dr. Owens and hand out to hand up, give your names to them or give you their information so that you can get listed in that document. Would that be something that you would do? I think I would love to have been able to go in and look for an estate planner for my friend and find a name, and knowing that I have somebody kind of like me who I could turn to, who knew what they were doing. So I would love to be able to do that. Can I do that?
That would be great. Not only could you do that, I would be extremely thankful if you did.
Yeah, because Mr. Owen actually had extended himself and listening to, God's purpose for him, and he is starting his own firm. So initially he was associated with Frost and Associates. So when we had previous worked with him, that's who he's with, but now he is his own firm. So we are essentially helping with growing his business. Clearly, when things like this happen, the networking happens itself, and then that's where the growth takes place. So we would love that.
That would be fantastic, and I would greatly appreciate that.
Yeah, and Dr. Owens, most of the people in the organization are not like me. Most of them actually have money, okay?
I'm not worried about who has money. I'm worried about who I can help.
Okay.
Yeah.
Thank you.
Yeah, absolutely.
Thank you. I'll get that information when I call.
Thank you very much.
Mm-hmm.
All right. So if we have any other questions before we end, and if not, we're gonna just go ahead and give a nice clap, clap, clap for Mr. Owens. Thank you so much for your time. Like I said, please take the time today to understand your personal situation and how you can develop an estate plan for you and your family. Please reach out to Mr. Owens, so that way he can help you with that and getting things accomplished in that sense. So other than that, thank you so much for being here. And please stay tuned for our next workshop, which we will post on our website as well as our social media. You can follow us at From Hand Out to Hand Up on Facebook and Instagram.